You've lived a great life and done well for yourself. But what mark will you leave on the world? How will you inspire future generations? Stan Miller and Katie Beth Hand have helped thousands of people answer exactly those questions. If you've ever wondered, what will be my legacy? You're in the right place. Welcome to the Your Life, Your Legacy podcast. Now, here are your hosts, Stan and Katie Beth.
Welcome to Legacy Leaders with your guest host, Diane Robinson, investment advisor with IP Financial Advisory Services, LLC. My guest today is Jocelyn Borowsky, partner at Duane Morris, LLP. So Jocelyn, tell us a little bit about yourself.
Well, hi and good afternoon. I am a trust and estates attorney. I've been in practice for many years. I graduated from the University of Pennsylvania Law School and have a tax master's from NYU Law School. I mainly assist high net worth clients with wills, trusts, and sophisticated estate planning.
Okay, so let's start with what kind of legacies do you see in your line of work?
Well, I see two general types of legacy planning. One is primarily for charity, and the other is people leaving legacies for their family.
All right. So can you expand a little bit on how you help families leave a legacy?
Sure. Well, as you all probably know, people can leave a legacy under their wills.
Mm-hmm.
And in a simple will, they can just give the money outright to their family, and that's it. But with legacy planning, people will do something a little bit more intentional. They will provide a fund that is more managed so as to make this legacy last for more than just one generation in their family. So the way they do this is they create a trust to hold the money, and they appoint somebody to manage that trust called a trustee. And the trustee will then manage the money for the benefit of the family members for as long as the money lasts. And so the idea is to provide for the family members, hopefully through many generations. We call those dynasty trusts. But also people do this during their lifetimes. If they can afford to part ways with money during their lifetimes, they will do the same sort of legacy planning for their families. Sometimes they will set up a dynasty trust for children and future beneficiaries, future descendants. Another very popular type of legacy planning tool is known as the SLAT, which stands for Spousal Lifetime Access Trust. So the idea is that one spouse will create a lifetime trust for the other, which will continue on after both spouses are no longer here for the benefit of the family.
Okay. So for the charity, what types of legacies are you seeing right now?
I see a lot of people who like to give to donor advised funds, and those are really easy to work with. There are lots of custodians of funds who can set up donor advised funds. I also have some high net worth clients who like to set up private foundations. Setting up a private foundation is a little bit like creating a new company because there are lots of rules and regulations that apply. For example, 5% of the private foundation has to be given away to charity every single year. It often has corporate rules that have to be complied with, tax filings that have to be made. So this is for people who really want to get involved and take a very hands-on approach. The easier way to do the same thing is really with a donor advised fund, and it's like a turnkey vehicle to make charitable gifts. For people who are not familiar, you can set up an account with a company. I'm just going to say Fidelity, because they certainly have Fidelity Charitable will run donor advised funds. You put an amount in, let's say you put in $2,000. That is your charitable gift for the year. And then throughout the year, you can interface with Fidelity and tell them that you, the donor, can tell the account custodian how you want your cash to be deployed, which charities it can go to. And in most cases, they will follow your advice. It's a donor advised fund. So if a donor advises something that is not permitted or is not charitable, the custodian will say no.
So do you help the clients decide what type of donor advised fund they want to go into, or do they usually come in and say, okay, I want to donate to XYZ foundation?
Yeah, it really varies from people to people, but a lot of times people will say to me, I want to do something charitable, and I have the conversation, well, should it be a private foundation? That's more high maintenance, or do you want to give to a donor advised fund? Or sometimes they have a very specific charitable organization in mind, and then we can negotiate a charitable gift agreement for them. If you're giving a lot of money to a charity, then that would merit a conversation with the charity's in-house people about how they're going to use that money or what they need to do to use the money. That's a conversation. Another thing I see a lot are people who like to take funds out of their IRA and give it directly to charity. It's known popularly as an IRA, charitable rollover contribution, and it has a tax savings benefit, because as people, when they get to be a certain age, they have to take money out of their IRA accounts. And and usually right now that age, I believe, was moved up to 73, but starting early as 70 and a half, you can do this charitable rollover, take out up to $100,000 per year and have it go direct to a charity. And that's a great benefit, because if instead you took the $100,000 out and just put it in your bank account and then gave it to charity, you might bump up against the limits on how much you can deduct against your taxes per year. Whereas that does not happen if you give it directly to charity. It's a complete wash. It's just better.
So you have a couple that they both have to do required minimum distributions. Can both of them do the required minimum distributions for the same amount?
Yes, they can. And in fact, starting next year, that amount will be indexed for inflation. So it'll go up incrementally over the years.
Okay. Are there some pitfalls to doing it? Some things that they should be aware of before they decide to do something like this?
Yes, there are. Well, not every single charity can receive a direct rollover. There are certain classes of charities for which this benefit is not available, such as to a donor advised fund. So you cannot do that $100,000 direct to charity rollover into a donor advised fund, even though it is a charity. And that's also true for private foundations. You cannot do it to a private foundation. You can still give money to a private foundation, but just not a direct rollover from the IRA. And also supporting organizations.
How would someone find out which organizations they can make that direct rollover to? Is there a site they can go to, or a list that they can use?
There probably is. There's probably an abundance of them. And I'm sure the IRS.gov has them also. And it's a conversation you could have with your advisor too. Diane, I'm sure you know what the list is.
I do, but I thought you might know. I was going to let you do it. The other thing they need to know is that it has to be rolled directly to the receiving organization. The check cannot be sent to the client and the client sign it and send it. That negates.
That does not work.
No, it does not work.
Right.
So there
exactly.
are rules. So,
yes, it's a direct rollover.
Yeah. Okay. So what kind of family legacies are you seeing? I know you mentioned the SLAP before. Are there other ones that people are looking at now?
Well, this falls under whether this is a lifetime gift or a gift that's made upon a person's death. And the reason people are making lifetime gifts of large amounts of money, there's really tax planning behind it. For people whose net worth is, let's say, 5 million or less, I think the type of legacy that makes most sense is one that will occur upon death after your lifetime, because you're going to need that money. So there's no reason to give it away now. For clients in the $5 to $10 million range, it's a toss-up, because right now the federal estate tax exclusion is very close to $13 million per person. So if you die and your net worth is around $10 million, there will be no federal estate tax. But that amount is going to revert back to $5 million as indexed by inflation in starting January 1, 2026. So now, so if you die after 2026, under existing law, only, let's say, half of your net worth will be not subject to estate tax, and the other half will be subject to estate tax, which is a 40% flat tax.
So are you advising your clients or the people that you talk to now come in right now to start planning for those types of events?
Absolutely. We've had a number of instances, particularly in 2012, where we thought the very generous estate tax exclusion amount was going to revert back to a lower number. So this might feel a little bit like deja vu, and then it didn't. But this particular law is written into the law. So it would take an act of Congress to change it, which in Congress isn't really functional right now. So there's a strong possibility that this reversion back to half of what it is going to occur January 1. And so I am advising people who are high net worth clients, and really these are people whose net worth exceeds $10 million, or I should say 13 million. But I'm advising those people to strongly consider making a lifetime gift. For people who are under 5 million, I think you don't worry about it. If your net worth is in that middle range, then I think you still need to come in and look at your testamentory documents, meaning your will, your revocable trust, and maybe you want to tweak them to have flexibility so that when the first spouse, if you're married, when the first spouse dies, the surviving spouse can get advice on what to do. What's the most tax efficient thing to do? You want to have your documents drafted in advance to take advantage of any tax efficiencies that will become known at that time.
Okay, so let's say I have 5 million or less. When I come in to talk to you, what are you going to be telling me, or what issues do I have that you're going to bring to my attention?
Well, if people are married, then you talk about what do you want your surviving spouse to do with the funds. If it's a blended family, oftentimes you need to have planning in place so that the surviving spouse can have access to the funds, but there'll be some left over for children from a prior marriage. If there's a blended family, there's definitely a need to have someone take a look at your will and revocable trust to make sure that everybody is happy and that you set it up to avoid failure, because there are a lot of fights that happen as soon as the first spouse dies. So you want to make sure those documents are not only drafted for tax efficiencies, but also so that they actually are functional and you don't have people appointed as trustees who shouldn't be trustees, and so on and so forth. So that's one of the things I talk about. I also talk about creditor protection. And let's face it, a lot of people get divorces and people's kids get divorced. And so for creditor protection purposes, you might want the next generation to receive their wealth in the form of a trust because it protects them. It doesn't completely cut them off of access to the trust, but it ensures that it sort of provides like a fence around the money so that it's there for them, but it's also not there for potential ex-spouses and creditors to just grab if there's a divorce.
So if they have life insurance, do you also go over the beneficiaries and help them set it up so that you don't have those problems where one child or stepchild gets left out and family ends up arguing and fighting?
Yeah, that would be really unfortunate, but a full intake interview would involve going over beneficiary designations for life insurance, for 401ks, for IRAs. Oftentimes, especially in family-owned businesses, people neglect to do the paperwork, and then somebody will die and might not be clear who the beneficiary is. And you really want to have a designated beneficiary for a lot of reasons that I won't go into today, but it's important to designate those people so that the money doesn't end up going into an estate which would then be subject to probate. It might be subject to additional fees. It might be subject to creditor claims. So it's very important to have those documents up to date and in place.
So what other documents do you recommend that everyone has in place and keep updated? Because I know a lot of times I talk to clients, they have a trust set up. Maybe they set the trust up 10 years ago, but the laws have changed a little bit and they're not aware of that. So the trust doesn't do what they think it's going to do. So how often do you recommend that people have their trust reviewed for those changes?
5 to 10 years, especially if there's going to be some tax changes. Like we know there are tax changes coming up in 2026. So getting ahead of that is always a good idea. Also, your estate planning attorney is going to be very busy in 2025. So if you can
make an appointment now, right?
Before then, the sooner the better, because they will be quite booked up. But yeah, so in addition to reviewing, you should ask your attorney to provide you with like a flow chart showing where everything is going to go upon death of the first spouse, and then if they're married, the second spouse, and to explain what the documents say and who are the trustees, who's the executor. Let's figure that out. That's important to review. Also, there are some ancillary documents that also could play an important role if somebody becomes incapacitated during their lifetime. It's good to have a power of attorney in place so that someone can write the checks, pay the bills, and also a healthcare power of attorney so that it's clear who's in charge of making medical decisions. And if appropriate, a living will. I sometimes call that the pull the plug document, but not everybody wants that to happen. So they should be clear about that also.
So if a client has a special needs child, what issues do they to be concerned about and what type of trust might be best for that person?
Well, if somebody does have a special needs child and that child might qualify for government assistance, it's important to have money go to them in a trust, and the trust has to be Medicaid safe, is how I phrase it. It should not provide for their support. Otherwise, it will be considered a resource of the person getting assistance and may disqualify them from important government benefits. So there's a way to draft a Medicaid safe trust. They're normally referred to as supplemental needs trust. And certainly if somebody has a special situation, special needs children, they should definitely seek advice from somebody who's in the business of drafting trusts, especially those types of trusts.
Okay, you mentioned flats. Are there any other trusts that our listeners should be considering, and why?
Yeah, I mean, there are life insurance trusts. Those are great because if somebody, let's say somebody has a family business and they have 2 kids and child 1 is in the business and child 2 is not in the business. How do you make it an equal distribution? Sure, you could give, half to one child, half to the other, but oftentimes the child in the business does not want to deal with the child not in the business. So oftentimes life insurance can be used to equalize gifts to children. And when it's held in a trust and the trust is drafted correctly, the funds going into the trust are treated as though they are not owned by the client when the client dies. So it saves money on taxes. And this is, again, especially important for clients whose net worth exceeds, let's just call it $5 to $6 million, anticipating that the law is going to change in 2021. So every dollar over that limit is going to be subject to a 40% tax after 2026. And so insurance money coming in would be better deployed into this irrevocable life insurance trust. It will be available for the family, but not taxable to the federal or state government.
So have you run into situations where that happened and you have the 2 children, the one that doesn't want to be in the business and the other one who wants to run the business? Is there anything you can do after the death to resolve that issue?
Oh, that's called litigation. And we suffered through one of those.
Yeah.
And they're not happy. And they're almost like a divorce when people start fighting about mom or dad's money. it just costs everybody money. It's a situation that mom or dad ought to want to avoid. But yeah, no, it's fixable post-mortem, but it's just not always an easy fix.
It's just pretty messy and hard feelings.
Yes.
So let's say you have a business owner and she's older and she wants to do things correctly. Should she bring the children in with her to talk to you, or should she just do it herself, or what do you usually recommend?
Well, I don't like to have other people in the room because of client confidentiality, but what I do recommend to the clients is to share their documents with their children so that everybody is aware up front what they're going to get. And most of the time, people just divide evenly among the children. But if there is a blended family or any situation where the kids don't get along, or a situation where maybe one kid is going to get more than the other, it's very important to get this out and in the open so that there is not a will challenge when the parent dies. We actually have a tool in Delaware that's very helpful if the parent is anticipating a potential dispute after the parent dies. And you can, we call it pre-mortem probate, but the parent can write a trust and circulate it to all of the beneficiaries named in the trust, really to everybody who might be impacted by it, with a notice letter saying you've got 120 days to complain. And if you fail to complain, you are time barred. And that actually can be very helpful down the road. Once the parent dies, the disappointed beneficiary will not then be able to say that mom, there was undue influence, or this wasn't validly signed, or something like that, because they had 120 days when the parent was alive to bring that kind of lawsuit.
So can you give an example of when someone did everything just right and how it affected them when that person died? So
what do you have in mind? Why don't you just go back to the last topic just for a second, just
okay.
to say that you don't have to live in Delaware to do this in Delaware. So if you had a revocable living trust, you could create it under Delaware law and invoke that rule, the pre-mortem probate rule. Or even if you have an irrevocable trust, same thing. You do not have to be a resident of Delaware to invoke that rule. You do have to be a resident to probate your will, but we distinguish between a will and a revocable trust and an irrevocable trust that is made during a person's lifetime.
Thank you for clarifying that. What I really was asking is, how happy are they when things are done correctly, well, as opposed to when they're not done correctly?
Yeah, I mean, done correctly is like the normal course. People are thrilled. The estate, there's always some frustration because an estate administration can take a year to 2 years, maybe 3 years if it's a very large and complex estate. So there's always some frustration over that. And even when the deceased client has put everything into a revocable living trust and thus has simplified the probate procedure, there still is a period where assets have to be collected, and there's always going to be some frustration over that. But yes, people are very happy when everything is streamlined and goes better than is expected.
Have you had to deal with some that did not have their setup correctly, and how did you deal with it?
Yeah, that of course always happens. You just do your best. Sometimes there's something called a family settlement agreement. If something's not quite right, you can challenge a will, of course, if there's grounds for it. When people set up trusts and it comes to light that it's not really working correctly, we have at least 4 different ways to modify them in Delaware. And in fact, lots of people, when they find there's a problem, after the fact, they will bring their trust into Delaware. And if that sounds strange, because it's not like you can pick up a trust, but you actually can move a trust from one state into Delaware and then use our 4 non-judicial methods of modification to fix problems that arise. So there are ways to fix things, and we do fix things all the time, even with irrevocable documents and even after the client has passed away.
So do you have a lot of trusts that get transferred into Delaware, or is it?
Oh, yes, many. And that's a whole separate thing. Some people transfer them into Delaware to fix problems, but sometimes people transfer trusts into Delaware because they like the Delaware laws. Delaware, under Delaware law, there's a lot of flexibility. We have something called directed trust, which when the client is still living and creates a lifetime trust, the client will often prefer to keep a hand in the trust investments. And we have a way to really conveniently do that in Delaware. And it's also at lower cost than a fully like a traditional trust that you might see in other states, where the trustee is going to charge perhaps a percentage of the value, which could run pretty high. We have low flat fee professional corporate trustees in Delaware who can step in as a trustee and provide the control to the client at a pretty low cost. So yeah, dozens and hundreds of trusts come into Delaware every year and are created initially in Delaware by out-of-state people every year. And in fact, Delaware is a tiny state, but we have at least 50 different trust companies here because this is such a huge business.
That must be a challenge to keep up with all of them. So, and I know you mentioned Delaware. Is that where you practice your law? Is that where your law practice is, or do you have other states that you cover?
Well, primarily I practice under Delaware law, but I am licensed in a number of different states in and around the region. I'm licensed in Pennsylvania, New Jersey. This is because earlier in my life, I moved around a little bit in the area with my husband, but have settled in Delaware for the last, I don't know how many years, at least 18 since I've been in this location. But yes, my primary practice is out of Delaware, but I do cover other states. And also I have partners. I'm in a large law firm. We have offices in other states. We have offices with estate planning attorneys in, besides Pennsylvania and New Jersey, there's New York and California and Florida. And those are our major practices, but also Massachusetts.
Okay. Is there anything I should have asked you today that I didn't ask, or is there something you think that our listeners need to know that we haven't mentioned yet?
Diane, you asked me everything that I thought you were going to ask me, and then some.
I
don't
try.
think you left any stone unturned.
So, well, let's do it this way. If I wanted to work with you, or one of our listeners wanted to work with you or your firm, how would they get in contact with you?
Well, they can email me, jmborowsky@dwaynemorris.com, but that's a mouthful. You could also find me on our website. I'll spell my name. You could probably find me on Google, Jocelyn, Jocelyn, and Borowsky, Borowsky. And I'm at Duane Morris, which is DUANEMORIS. That's my law firm.
And they can find you on the internet because I've searched for you. So you're there.
I'm also on LinkedIn.
Yes.
There are probably a half a dozen ways to find me. But yeah, a Google search will certainly put you right in touch. And since my name is so unusual, I don't think you'll find more than one of me.
Well, maybe we should spell your last name so they know they do it correctly.
I'll respell it.
Okay.
B as in boy, OROW, S as in Sam, K, Y as in yes.
Okay. Is there a telephone number they can call as well?
Absolutely. My office line is 302-657-4921.
Would you repeat that again, just in case they didn't write fast enough?
302-657-4921.
Okay. Well, thank you so very much. This was very interesting, and I learned some things too, so that makes it worthwhile for me as well as for our listeners. So,
well, thanks for having me, Diane.
Well, you're more than welcome, and I'm so glad to have you here. It's nice to have some women on the show. So thank you again. So listeners, if you're thinking about talking to an attorney about legacy, you have Jocelyn's name and number. So please give her a call and contact her. And unless you have something else you would like to add, Jocelyn, we're going to say goodbye.
Well, thank you. Thanks for having me. My pleasure.
Okay. Goodbye, everyone.
Bye-bye.
Thanks for listening to the Your Life, Your Legacy podcast with Stan Miller and Katie Beth Hand. If you enjoyed the show, please rate, review, and subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts. To find out more about Stan and Katie Beth, go to pinnaclelegacylaw.com. You can also find links in the show notes.